Ladies and gentlemen, welcome back to the Indie Zone podcast. My name is Kathy. On the 24th of February 2025, the defense filed motion in limine number 5 regarding inconclusive data, and this had to do with some testing of the fingernails of Madison Mogen and testimony that was presented to the grand jury, information that's being released to the public, at least according to how the defense is laying out the facts here for the first time. What is the defense saying exactly? Well, on page 1, it states here that Mr. Kohberger is seeking an order limiting testimony about the statistical analysis of item Q13.1, fingernail clippings. Allowing such testimony, according to the defense, would violate Mr. Kohberger's federal and state constitutional rights, and he gives the provisions of the United States Constitution, the Idaho State Constitution, and also cites to various criminal rules and rules of evidence in Idaho. He then states the requested limits are made, quote, to secure fairness in administration, to the end the truth may be ascertained in proceedings justly determined, and furthermore, that the above requested matters are ripe for consideration by the court are based on the existence of issues that involve preliminary questions of admissibility. What does this mean? Requested matters are ripe for consideration. That means that this is a properly brought forward motion seeking relief in the form of an order in limine pre-trial as to the relief sought, as to limiting testimony regarding these matters. Now, under the statement of facts, it is heavily redacted. You're going to see it beginning approximately the middle of page 2 of this motion. Going on through page 3, you'll see the redactions. And basically what we're being told here as the public is that there was some testimony at the grand jury proceedings. Remember, they were secret. They were held in Latah County in May 2023. The defense was not present. This was the prosecutor's show where the prosecution is bringing on evidence and attempting to convince the grand jury to return an indictment, which the grand jury did. And the indictment has charged Mr. Kohberger with 5 counts of first-degree felonies, which the state of Idaho is seeking capital punishment as a possible sentence for if he is found guilty at the upcoming trial, where the state of Idaho, at all times relevant, bears the burden of proving to that jury beyond a reasonable doubt by a proffering of admissible evidence that Mr. Kohberger is guilty of these crimes. The redacted statements here, beginning on page 3, addresses the fact that Jade Miller apparently gave some testimony as to her findings regarding these fingernail clippings. There's a lot of mathematical information. There's an identification of a statistical information, the likelihood ratio, LR, and basically what the defense seems to be arguing here is that in her testimony, Miller did not provide a full context to the analysis. There were statements made that the DNA were contributed by 3 sources. There was an assumption made that Ms. Mogen was one, and what the defense seems to be concerned about is that Mr. Kohberger was not eliminated. And there could be a presumption, they feel unfairly, that because he wasn't eliminated, he could still be considered as a contributor to one of those DNA sources. So now what they tell us for the first time is that apparently, and they say it here more importantly, Mr. Kohberger has disclosed that through further independent lab testing, he is eliminated as a contributor of item 13.1. So therefore, in the conclusion, a fair trial is mandated by Mr. Kohberger's constitutional rights to due process, a fair trial, effective assistance of counsel, and confrontation of witnesses. And finally, expert testimony improperly elicited must be excluded. And this is signed by Bicca Barlow. We will await to see what the state of Idaho has to say about all of this in their forthcoming response to this in limine motion, which is due on or before March 17th. Until then, this is Kathy. Thanks for joining us here today.